si on couvre le Bénin, ah bah là, attendez, Bénin c'est loi pays, alors attendez. Je dis ça parce qu'on a eu exactement cet après-midi cette discussion-là. Et puis, quelque part, nous, on a tous les tableaux Excel maintenant en place pour dire, ben, tu mets un 0 ou tu mets un 1, puis que ça te donne un peu une espèce de total, quoi, par pays. Et donc, en fait, on a quelque part, cette info, elle existe. C'est clair que ce serait très confidentiel employé. Enfin, ou disons, il faudrait vulgariser ensuite, enfin, complètement théoriser le truc pour le... Ouais, non, c'est clair. C'est clair. Ouais. Et puis, même pas seulement un client externe. Si tu bosses dans une boîte, c'est une évidence que le budget, c'est le nerf de la guerre. Et comme le légal est en général un centre de coût et non pas un centre d'investissement, il faut que ça soit les dépenses les plus basses possibles.
So welcome back in a different room for this session where the idea is in essence to learn from practice and more specifically from Chantal Colère. I'm very grateful that she could make the time also because she's about to go away for a quite extensive period of time. So Chantal is a very established IP practitioner with most extensive experience. She's been now for a couple of years visiting us at the law school, also in her capacity as part of the leadership team of AROPI, which is the Association of IP Practitioners from the French-speaking part of Switzerland, which actually may be of interest to you, and perhaps you may want to say a few words about AROPI at some point. And the idea really is to make it possible for you to have a hands-on experience to understand and practice what that means to do a trademark search, and that's really to do some really practical experiments around this, and that is really fully aligned with what you heard a few hours ago from Gregor Zondert from Procter & Gamble.
Yeah, right.
I'm sure you know. Who also pointed out to the importance of freedom to operate, freedom to use issues. And this is the type of issue on which we should be focusing. So without further ado, and I thank very much again Chantal for being with us today, and I leave you in her good hands. Thank you so much.
Thank you. So thank you for the attendance and the interest in IP. I know I've read a bit of your backgrounds, that your short introductions of yourselves, maybe just a few words about myself. I was born and raised in Geneva, was in law school here, actually the first year that this building opened, so I think I actually had a history of law exam in this room, very bad memory. So I'm going to try to exit this room with much better memories. Ever since finishing law here, I moved into IP. I mostly worked in IP firms in Geneva. I also spent a couple of years in-house as an IP manager for a vodka company, and a couple of years in Lausanne for a sports federation. So I had some insights of what it is to be in-house, an in-house counsel, and be very close to marketing department, other parts of the business. But I realized that my DNA somehow, what I preferred to do was to be a counsel in an IP law firm, because it gave me the opportunity to look into very different projects, very different aspects of different types of clients, different sizes, different fields of activities, different products and services. And it gives me a lot of insights of how to switch from a startup to an individual applicant to the big corporates to the multinational that is using my services only in Switzerland. And it's juggling with all these different types of clients that gave me the experience now 27 years later. So it does add on every year. And it gives me the feeling, the gut feeling that I can try to convey a bit to you today. It will not always be easy, because a lot of probably some of the questions you will have, I will have to answer. It's a matter of experience if you know to go left or right, or if this is a thumbs ups or thumbs down for the project. So I'm going to try to make it as objective as possible for you to list some criteria and have some takeaway points. But in the end, in what I'm going to show you, there's 27 years of practicing, of sweating over the searches. Trust me, I've done a lot of, there were some years we did probably 50 a week, and it was horrible. It's one of the worst nightmares of an IP council, to do searching and searching and searching. Why? It is also one of the most difficult exercises, because you're trying to anticipate the future. You're trying to see what other companies might do to your project or your client's project. And that's one of the difficulties, is to assess the risk. Just to tell your client, whoever your client is, whether it is an external person, like for me in an IP firm, my clients will be other businesses, but if you're an in-house counsel, your clients will be the internal other departments, marketing, finance, CEO, whoever, product team, etc. So trying to satisfy your clients, that's one thing. Trying to make it accessible for them to understand what you're conveying as a message is another thing. Trying to fit the budget. We just talked budgets with Professor de Vera. It's one of the important things too. And in the end, there's one thing also, covering your ass, which is a big thing. The liability of conducting searches is quite important, because it can end up in quite severe consequences for your business or your client's business if you made a mistake. So it is not something that you just dive into and say, oh, I'm going to play a bit with the data, and then, oh yeah, maybe this is good or maybe this is not good. When you're doing this for your own projects, that's fine. When you're doing this and you're trying to sell your competence around searching to someone else, you have to have a good list of a good methodology, I would say, that you can walk your customer, your client through to bring him to this, to understand why you came to that result. And in the same time, say, but I did not cover this, I did not cover that, and I excluded this from my search, because you cannot search the entire world. Okay, so we're going to try to see how you can frame things, to dive into something more concrete, and try to play a bit with the tools, so that you can experiment with your own data, ideas. Some of I have some ideas. You can test some names and some logos that we can go look up. And then we'll try to see what triggers some questions for you. And these are usually, and very likely, the questions my client come back with. They're logical, so don't be afraid to ask any type of question, because nothing's straightforward. It's all about shades of gray. Okay, so let's see. First things is to understand a bit of the context. One of the methodology I'm using is what I call the 4W strategy. Basically, what you're going to do in this course, in this atelier, is to create value for a company. Okay, brands and trademarks and IP rights are assets for a company. They're not easy to put a financial value on, but nevertheless, they have a great impact on the business value. And there are companies that do valuation and to end up being able to give a price for a certain brand. Especially when companies are selling brands to each other and so on, you can put a price on a brand. But basically, the idea when you build a brand and when you come up with something new, a new project, is you're building value for the company. And to build this correctly, you want to use those 4 W questions. What for, who, and where. I will share this so you don't have to copy everything. I'd prefer if you try to listen and understand what we're talking about, and then you will practice that anyway, so it will become something more natural. So the first thing is what? I put this cup because for me it's the perfect example. We usually take the Coke bottle or the Coca-Cola brand because it has so many different aspects that are well known, but we can take a coffee cup of Starbucks or anything just to illustrate the concept. Which portions of the brand you will be creating, or you are creating for your client, or helping your client to create, etc. Which portions of this brand, of this corporate identity, do you want to capture as a trademark or as an IP right? There's the name, of course. So if we go back to the Coca-Cola bottle, you will have the Coca-Cola name, or Starbucks name, or any other brand name. That's one aspect that you want to protect because it is usually the core, the essence. Okay, this is how you communicate non-verbally, non-visually. It's how you will use it in domain names, on any small typos and things like that. So the core will be the name. Other aspects, if your product has a shape, a color, a logo, all these aspects you want to capture, which means also you also want to search for those. Because the idea of searching is seeing if you're going to step on anyone's toes that is already out there, that is more or less aggressive. Okay, so you don't want to step on somebody's toes that is extremely aggressive, and that's all the things we'll have to look into. So first thing is what? What are we searching? What are we creating? Okay. Usually when you come up with an idea for a new brand and you're going to look for a new name, you're going to come up with a list, a short list of 5, 10 good names that you think are of interest. Search those. Try to make a ranking. Which ones will be more interesting in terms of legal risks? Less interesting, too risky, let's discard those, keep the more interesting ones and dive a bit further into the search. Okay. Second thing is what for. I'm pretty sure you're now familiar with classes of services, goods and services. Have you talked about the NIS classification?
Some of the students know, but perhaps you can briefly.
Okay, good. The international norms for accounting have classified businesses in certain categories. From there, the agreement of NIS was set up. I can't remember when. The dates are not my, as you could understand with the history thing. Dates are not my favorite. But anyway, the NIS agreement put a frame for these activities to be split into 45 different classes. Classes 1 to 34 are for tangible goods. Classes 35 to 45 are for services. So this is extremely important. You cannot register or apply for a trademark registration for all goods and services. You need to frame your project. So I know that you are in 2 different teams and that you're going into fast-moving consumer goods and into luxury, but that still does not give us the type of goods and services that you will address. What are the examples that you have already thought of? Yeah?
We have the luxury brands and we decided to register a watch and we saw it was class 14.
Exactly, correct. Any other ideas? Nothing yet? Okay. So I'll try to find a bit later a link for you to see which classes are, which goods fall into which classes, so that you have a reference also you can use. But basically you have class 3 cosmetics, you have 29, 30, 31 are classes for foodstuff, 32, 33 are for beverages, non-alcoholic and alcoholic. 34 is for tobacco. Bags would be class 18. Class 25 is for clothing, etc., etc. Class 9 is for glasses. So you have all these classes, and they are important because you cannot search for everything. Otherwise, you're going to end up with way too many results, and you don't know what to do with them if they put your project at risk or not. So that's one of the most important aspects also. Huh? Third one is who will be the owner of the brand. It's not extremely relevant for the searching process. But when you build a brand or when you advise anyone that is going to set up something, you're going to have to always think about who's the owner. Is it an individual behind the company, the CEO? With startups, it's very often the case. Okay, so, or small and medium enterprises, also like family businesses. Usually, you end up having the older dad taking all the brands under his name, and then in the succession of the company, you have a big mess to transfer the rights to the company, etc. So this is also an important aspect. In a structure of big companies with holdings and operational businesses and so on, you also want to have the IP ownership under one roof. And ideally, you're going to discuss this with tax aspects, link it with tax aspects, because you're going to have some kind of tax relief if you do IP holding that licenses the brands out and things like that. So that's one of the aspects, not very important for today, but just so you keep it in mind, ownership is also as one of the pillars of a good IP strategy. And finally, where? I think you should know now that the IP rights are registerable by country or by territory. It's a territorial right by essence. Of course, for domain names, you have GTLDs, like the .com, that are worldwide, but that does not exist for trademarks. So every now and then, I have a client comes and says, yeah, I want to protect the whole world. 3 million. You're sure you're having that budget? And they say, maybe not. So you have to go to select which countries you're going to cover. Okay. So these 4 pillars are how to structure your approach to a brand construction and to searching the way we are going to do it. Is this clear, or does anyone have a question? Okay. We'll come back to that. Don't worry, I can flash it whenever you need. Sure, I saw you.
Maybe it's a funny question, but what if a product is 2 things at the same time? For example, I don't know, like a cloth with a watch on it. Can we classify it? And do you have to choose what kind of product it is?
No, and it's not a funny question. It's absolutely relevant. You will want to cover both classes.
Okay.
The classification in itself is not the only exercise you're going to have to do. It's to identify the 2 classes is important, or the several classes that your product covers. But once you apply for the trademark registration, you're also going to have to see how you're phrasing the description of the product inside each of the classes. And every trademark office in the world has their own practice to this wording. And this actually is, I would say, 60% of my business, is to adapt the wording. So it is absolutely not a funny question, it's a very essential question. And it happens quite often that clients come up with a project that you don't know exactly where to classify, especially when The project stands from a startup that is innovating and bringing something completely new to the market. And every now and then we do have to build the practice with the trademark offices to educate them.
For example, there are like rings that have watches on it. So do you put
and monitors of your heart rate and your sleep and so on. So it has other aspects of technology. So you put it in the category of watches or of, gives you the time maybe, and then it connects with your phone, and then, all the connectors and the captors, and so it does cover several classes. Mm-hmm. So, I suggest that, maybe just a few words about liability. It's not the core of your project, but what I'm going to tell you as a message here is important for you for the years to come. If you're using what you learn here to go into IP as a profession, you will want to understand that whatever result you give, or whatever, because basically, giving out a search report to a client is pretty much putting your head on the I don't know how you call it in English, but I mean, you're pretty much putting your hand and they can cut it if you're wrong. So it is not something you do lightly, huh? And you will want to, in the report, phrase things so as to say, this is my opinion, this is how I perceive. If they chose a bad attorney, it's kind of their responsibility too. So you shift a bit of the responsibility to the client also. Second is you always have to indicate where you have your data from. So if you use, and this is what we're going to use today, public accessible records, you also have to say that very openly to the people you're giving your report to. We used tool, this tool, that tool, or whatever, public accessible databases. Therefore, we are not certain that it covers everything up to today. You will see timing is an important element. And if you use professional databases, at a certain point, I'll show you. We'll go into public databases and see what kind of results you can obtain, and then we'll compare them with a professional database. And then it allows us to see if it's good or not, okay? In the professional databases where we pay a subscription of 5,000 to 10,000 a year to have the data, they bear the responsibility if they did not give us all the data that is relevant. And if you even want less responsibilities, you can go to these suppliers who have these professional databases and ask for them to conduct a search and to give you a report that you pay consequently quite an important price depending on the geographical scope. But they bear even more responsibilities. And then you only interpret the results. And you tell your client, whoever it is, it's a go or a no-go situation. Okay? So shifting the responsibility at some point and the liability is important because the exercise is not an easy one. But I'll suggest to do something concrete so that you get a bit of an idea how or not it is easy. So let's go to this website. Either you go to Google with TMView, or you type the tmdn.org/tmview. You'll land on this page normally. Can you find it or not? Otherwise, you go to...
It doesn't seem to be loading.
Are we too many on it? other way, try through euipo.europa.eu. And then, if you're on this page, you go here, look into the IP databases, and you are again in TMView. That works?
Yeah.
Wonderful. Let me just look then at we want also to have this, so this is NCL pub, it's NIST classification publication, .wipo.int. And this will be your tool to understand in which class your products are fitting. Maybe you can find another one, give me 2 seconds. Where you were before, you also have TM class that works pretty well. That's the European one, but it's quite good also for international purposes. So you have the WIPO one and you have the European one, which work both quite well to search for goods and to see which classes they are in. So now in either tool of the NIST classification, so either in the TM class or in the WIPO one, try to find which class is the right one for shower drains. That's not a luxury good and it's not fun, but you'll see there's a lot happening in that class. Search. Has anybody started to search? Did you find it?
Is it in the class 20?
No, normally not. I mean, you could have some shower elements in class 20. What else?
Is it class 6?
Some are in class 6 because all the metallic goods are in class 6.
Class 3?
Class 3 now that would be more the cosmetic part. So you probably have a wrong understanding of the words with shower something of the database.
7 maybe?
7 would be all the plastic elements. Shower and grease does not exist in the selected. Okay, so let's search again.
11?
Yeah. 11 is the right class. Give it to me. It was a difficult one. I had to search also for the first time that this client came to me. Anyway, this client came to me with the project. I have a new innovative drain system for showers that is beautiful, that is all metallic, and you won't see it pretty much in the shower, in the Italian shower you build, and so on. And it is seamless also, so he's all happy about his project. No? So it's the best thing ever. I want to call it Starflow. Okay. So first things first, you have to look if the trademark that is proposed by your customer is going to be registerable. Have you ever heard about distinctiveness? Is this a notion you're familiar with? Okay. So Starflow, Flow Star, because he said you can turn it the other way around if you prefer. It's like, okay. Anyway, Star is very laudative. Laudative means it's putting the qualities of the product to the forefront. Trademark offices don't like that too much. The Swiss trademark office hates that. So pretty much that's a no-go. And then flow is rather descriptive of the purpose of a shower drain, right? Is to let the water flow. So all in all, the brand's not very, very distinctive.
So can you repeat how you say it in English? Putting the quality of the product.
To the forefront somehow.
Yeah, how do you call it?
Laudative.
Relative.
Mhm. Yeah.
Why have you said that Strategie is in Deutschland?
It is a bit like terms like master, premium, and all these terms that are not directly descriptive of the quality, but that are laudative, that are making the customer understand that it is the best product on the market. As you probably now know, a trademark registration offers the owner a monopoly over the terms they register. If you give a monopoly over those terms to one actor of the market, you're killing the fair competition. And that's the main reason why trademark offices don't accept trademarks that are too descriptive or composed of terms that should be used by any actor on the marketplace. For this reason, the term star, not ideal. Flow, descriptive. Maybe put together could give something that is not too bad. But I already told the client, oh, not the best brand ever, but let's see. He said, oh, okay. If it's not the best, I want something with flow for sure, because my team has started to talk about this product as flow. Whatever it is, it has to contain flow. So my suggestion is, let's use the tool to see, because I did the search already, you know, so I know what's coming out. But your turn to find out a bit the aspects. So you're gonna go to this TM view, and this first database, this first page is the basic feature of the tool, and I would suggest that you go to the advanced version. So mine is in French. Is it a problem? Should I switch to English, or is it okay?
Perhaps it's better for those
Where is English? Voilà, merci. Here it is. So, here you have three versions. Either the whole word, it begins with, it ends with. Then you have fuzzy search, but with a term like flow, we won't use fuzzy search. It's something you can use when you have a very, very strong name. And is will be something completely identical. So I suggest we start with is. We type flow here. And the tool already gives you a few suggestions of what it knows to be there. So we already see we have some flows, huh? But let's leave it there, just type this. And then you're going to the classes, goods and services here. And if you go to the right arrow, you're gonna have a list, a menu, where you can tick class 11. Okay. And then I would suggest that we limit the search to some countries. So here you have either territories or offices. The best way to proceed is with territories, because you will want to include all the offices in that territory. Let's do Switzerland and Europe. That's already quite important. So if you just click on this field, you already have here a few selections. I would already take EU as European Union, and you see in offices it gives you all the offices of the European Union. And then you're also going to type CH for Switzerland. and you add Switzerland, and you have a whole list of countries. Does yours look like mine? Yeah? Okay. And then click on search. So what we have is a list of results that comes out either in form of a list, or you can have it as a gallery view as well, which is much more useful when you search for these devices, for logos, okay? So let's stay on the list view for the word marks. And here, from now on, you see already you have 33 results. That's the number in the middle here. So that's not too bad, especially because we see that quite a lot of trademarks are already expired or ended. So we're going to get rid of those to start with. You're going to have to go to the filters on the left and click only filed and registered. And then you go on apply to the top. I'm not sure if everybody follows here. We're good? Okay. Which is going to discard all the ones that are dead, basically dead rights. Once a trademark has lapsed or expired or has not been renewed or has been cancelled or etc., it is taken off the registry. Their owner cannot do anything against you anymore. So you can really get rid of those. Sometimes they are interesting to gather other type of information on a certain owner, on a certain product that used to exist, etc., etc. So it's always useful to see them, but not in the frame of a search for a new product and to assess the risks for a new product. Okay. So here we end up having only 16 results. So we got rid of half of them, which is quite good. But remember, we're just looking for identical marks because we said the trademark is flow. All right. And we're still in class 11 and then a few other ones. So I would suggest that you take some time. Let's take 3 minutes. You go through the results you have. You can click on each and one of them and you're going to open a new page. See what type of goods they are actually giving you. Here you have class 11 and you have some goods. You can switch the language here, which can be useful sometimes. And you're going to look through the rights, one after the other, and kind of try to imagine what you would like to tell my client who wants his product named Flow, or Flow something. So I give you 3 minutes and then we'll talk about it. You can ask questions, huh? If you I'm happy to answer.
I think I found the exact same product.
You found the exact same product as hit number how much?
We just in Switzerland, the 14th of August.
Do you have a number or an owner, an applicant?
France, Galdeval. Juste en dessous. Oui.
This one.
Dessus. Non,
C'est pas grave, je vais remonter.
Ah, c'est
This one? That's not a Swiss one. This Swiss one?
Yes. And search for this. Ah.
Do you have the same number here?
No.
No? What number do you have? There's normally a number to the at the top.
Application number?
Yeah?
01.
Okay, this one.
Yeah.
So that's a European one. Okay, that's a European trademark. Registered, however, by a German applicant here. Yeah. And it is the same trademark as the next one. This one is registered in Europe. The next one is registered in Switzerland. Because, of course, Europe being the European Union, Switzerland is excluded of it, so you have to have two different rights, okay? And they will appear both. So, exactly, you found an identical trademark. Registered in 2023, which means it's not even that far back in time, which is quite surprising. Because for me, the term flow is really non-registrable, and which means that in 2023, apparently, the Trademark Office of the European Union, and because it's the next one here, the Trademark Office of Switzerland, also in 2023, decided that flow was completely registrable and that somebody could monopolize it. So here again, you have sanitary and bathroom installations, sanitary drain. Yep. So you find an exactly identical trademark. This is an absolute no-go for a project. Especially when you start something new, you don't want to start something new with such a risk above your head, okay? It's really something that does not make sense when you go and present the results to somebody and say, oh yeah, there's a company having the same brand, and go ahead because it means you can register it. No, yes, or let's put it this way. Yes, in Switzerland, in Europe, you will achieve registration eventually. If the trademark office says it's distinctive enough, you will get the trademark registration. You will have a paper. But after registration, this owner can file for opposition. They can attack you because you're not allowed to use and to register the same trademark as they have monopolized. And if they attack you, not only is your trademark registration that comes at a later date, so the younger right is going to be cancelled, but it's also, if you started a business and if you damaged their business income, reputation, etc., you are going to eventually be in front of a civil jurisdiction, a civil court that will also claim, they will claim some damages, some money, basically, to cover their damages. Okay? In Europe, we don't have punitive damages, which means you're not going to be punished paying several millions because you did something wrong. But you will have to cover the financial loss of the owner of the older mark. And your trademark is going to be cancelled, which means you have to rebrand your project entirely. Do you start to understand how things are? Okay? So now what I want, yeah, sure. Sorry.
There's another one.
Mm-hmm.
Application date in 2025. Application number is 01923.
Do you know the country?
EU.
Which one did you have? Well, who's the owner, you said?
The BEM retail.
Yep, this one.
So this one's for, it's be enough for you to say we shouldn't be filing under the same?
That's exactly the question. You have the concept of identity, and you have the concept of similarity. In most cases, you will have to assess the risks of similar trademarks for more or less similar goods. And that's where experience comes into play. You have to look at how similar are the signs, how similar are the goods, and there the criteria. You can look up, for those who can read French, it's on the directives, the guidelines of the Swiss Trademark Office are quite good on this topic. But the EU IPO also has some guidelines in English that you can probably find and who explain quite well also the similarity between different types of goods. The criteria are, is the supply and the distribution chain the same? Is the end consumer the same? Are the sales points the same? And are the goods replaceable, substitutable, in the sense that can you use a pen for a pencil to the same effect? These are the main criteria to judge whether goods that are not exactly labeled or worded in the same way, if they should be considered similar or not, and if they create a risk for your project or not. Does that answer your question to start with? Now to come back exactly to this specific case, class 11 is a quite restrict class. It's a quite focused class in the sense that it has all the sanitary stuff and all the electrical light stuff. Usually you can find those in the same type of stores, and they address to the same consumers, because when you build your house, when you redo your bathroom, etc., you're gonna try to combine the shower and the lamps that you have in there. But case law has shown that you can kind of put some kind of a dissimilarity, not a complete dissimilarity, but some kind of distance between the two categories. I chose this example because I find it quite interesting in class 11. It's a quite easy class. But if you go to class 9 that has so many goods in there, where you have glasses, eyeglasses, protective helmets, fire extinguishers, cash registers, software and hardware, here you have some very distinct categories. And case law will only tell you if goods are similar or not. And every country is different. In China, for example, case law is not that important, but they do have subclasses. In each class, you have 11.1, 11.2, 11.3, up to I don't know how many, and they list each type of goods. And then they categorize them. They cluster them. 1 to 10, for example, is the same. And then 11 to 20 is considered similar. And I don't know it by heart. I always go to my Chinese counterparts because they know it by heart. But sometimes goods that I would not consider being similar under my standards would be considered as belonging to the same subclass in China, for example. So here you see also how important it is to understand which country you're going to. Where is your project expanding to? And what are the risks in each country, or in each, at least, geographical area? Okay? So in this case, I would say yes, it is, this specific trademark is also a problem. Not as much as the one before, but still. And at the moment you have a very high risk, you can continue listing less important risks to a client and say, and on top of that you have this one and this one and this one. It will show you and show him that the project is even more riskier. Now, there is a counter argument in all that. That's brain gymnastics. And very often clients come back with that though. They will say, but if everybody has flow as a trademark, and they were all able to register them, and they coexist, why couldn't I also come in there? True. True aspect. You can try. No problem. You probably might obtain a registration even based on the fact that you have 2023 and 2025 registrations who passed the bar of registration with the name Flow. And you say, oh, but these guys made it, so I should be able to make it too for an equal treatment, huh? But then, each of them might attack you. Because what you don't know is that possibly these companies are linked to each other, and they did not attack each other because they are linked, they are connected, or because they concluded an agreement. Peaceful coexistence. And that is something you have no way to have information. All these elements are secret to these businesses. So that's the main problem. It's what you search, but once you have the search results, what will you understand also from the results? Another aspect. Let's go back to these results. Let's take this one. Almost. No, this is not the right goods. Still not the right goods. This one was not a nice one. That is the 2023. Anyway, maybe you know, maybe you don't, but it's also a good thing to note down. Trademarks that are older than 5 years after their registration date should be used as they were registered to be kept valid. This means that a trademark that is older than 5 years, here it's not the case because it's a 23, but if you have something that is older than 5 years, you should check the owner's website. Try to find if they do sell the branded products. If they do, the risk is higher. If they don't, the risk is lower. That's also an element. So in the searching methodology, you have classes, countries, how you search the term, the searching term, then look at the results to take only the relevant results, and then in the selected results that you find risky, you're going to have to look into if these trademarks are older than 5 years, and if they are in use or not. It's like a big thing, and you have to open the drawers, huh? One after the other, or the Russian dolls, huh? So once you discard one risk, you go further, you dig further, and you look if there's more risks, etc. Yes?
Must you go before a tribunal to get a trademark invalidated?
Yep.
Or could you just write to the office and say these people don't seem to be selling?
There's invalidation is in front of, especially in Switzerland, is in front of a court, a civil court. But oppositions are administrative procedures that you can go through in front of to the office, the trademark office. Every trademark that is in the registration process will be published for third parties to oppose. And you usually have 1 to 6 months to oppose. 6 is not, in Switzerland you have 3 months, in the EU you have a bit more, 4 months I think. But there's a deadline. Let's take an example. If we go here, go. You can look at the timeline of a trademark. You see here you have an application. Well, this was gone through an international mark, so it has a bit of a different beginning. But here you see, I'm again in French. Let's move over to English. Where is English? Here you have start of the opposition period, end of the opposition period, and in between you have 0 opposition received. So this one was good. But any third party who has a valid earlier trademark can file for opposition. So your trademark is never registered safely before it has passed the end of the opposition period. And this opposition period is sometimes within the examination process and sometimes after, depends on the country. That's also one of the difficulties of our profession, is to know in which country when the timeline, of the risk timeline comes up, okay?
Usually, on average, how long would it be?
How long the opposition period? 2-3 months. If a third party files for opposition, it can last up to 2-3 years until the case is concluded. All the offices claim that an opposition procedure is an administrative proceeding that is meant to go fast and to be cheap. Not true. In reality, it's 4, 5, 6,000 of whatever currency you want, but USD, Euro, or Swiss francs are now approximately the same. It's quite a consequent budget, and it will take up to 2-3 years to have a decision. That's also a risk for your client, your project, because it will only delay the time of registration of your trademark, which means that if you create a brand and you go into a very crowded environment where you have a lot of trademarks that are very similar, your risks of being attacked are higher. So you increase the chances of having more cases against you. So it's not only a matter of will you win in the end or not, it's how much are you able to handle these cases, because usually when you start a new project, you don't want to care about trademark oppositions. You want to care about building up your product and finding the right consumers and making your marketing and etc., etc. You don't want to deal with that and delay the launch of your product, betting on the fact that, yes, but I consider legally that we should win this case. Yeah, well, okay, that's your concept as a lawyer, but the product people and the company, the business owner and so on, they want to move ahead with their projects. Okay, so the crowded environment of when you're in trademark search, the more results you find, the more risky the project is in terms of timing, finance, and just hassle. I mean, just problems that you will have to face and deal with. So you want to choose some rights and create brands that are not going into a crowded environment.
Isn't it possible to purchase a non-used brand that is registered but not active?
It's completely possible. You would have to go to the owner and make an offer. Your experience demonstrates that owners are very reluctant to sell their trademarks. And I've seen maybe in my career 2 or 3 brands that were purchased. That's all.
No, not that much.
That's not that much, yeah.
Are there cases like cyber squatting, but in TM, like trademark?
Absolutely.
Yes.
Absolutely. And one of the messages I wanted to convey today for word marks, before adopting a trademark, I mean, once you've done your searches on trademark names, etc., etc., you will want to check also if the main domain names are available for your project. I mean, now for the classes, I mean, for the workshop, it's not that important, but in real life, when you want to open a business, if you're not able to have your main extensions with the name of the brand, it's kind of a no-go situation. Because if you can't have the .com and you can't have the .country where you will operate your main business in, it's very difficult to then promote yourself and build up a whole marketing. When you start looking for domains, make sure you're very quickly able to purchase the domains if they're available. And make sure that you've somehow cleared the trademark already, that you will eventually then find a trademark. Because what happened to me several times, and just even more than marks that were purchased, I've seen that when we conducted some searches on domains, people were grabbing the domain name in .com because somehow with tools powered by AI now, they notice that you are doing searches for those names. And that's one of the problems with domains, so trolling, but then you will end up with a similar situation in trademarks. If you are able to demonstrate that the trademark application was done in bad faith, at least I would say in most countries in the world, but you have to prove the bad faith of the applicant, and that's not always easy. So yes, there is a lot of trolling, especially because the rights are territorial. For example, now you say, I will launch my trademark in Switzerland and maybe Europe, and I will cover these two countries because I don't have more budget to to register the trademark. But then in some other countries, somebody's coming up and taking the same trade and registering the trademark instead of you. And you'll have to to try to send them away. We'll make a break.
We will take a 10 minutes break and then we can all come back into this room.
C'est ce que je craignais. C'est arrivé.
Jeudi prochain.
Non, jeudi prochain, je serai à Osaka.
Très bien. Vous avez déjà été sur
Oui. Le Japon, c'est un des pays où j'ai beaucoup de clients. Ce qui fait que ça va faire une tournée.
Incroyable. J'ai envoyé un mail à Monsieur Sacrou déjà 2 fois.
D'accord.
Parce que il m'a envoyé la quittance pour payer les frais, mais c'est toujours étudiant, c'est toujours 40 francs normalement.
Oui, normalement. Il faut pas hésiter à payer que 40 francs, ça sera.
Bon, je vais voir avec lui la semaine prochaine.
D'accord.
Voilà. En tout cas,
vous pourrez venir aux conférences après. Il y a des trucs vraiment très intéressants. Les prochaines sont au brevet, mais en février, il y en a une sur les marques qui est vraiment très bien.
j'étais chanceuse parce que j'ai rejoint la REPI l'année dernière et c'était rigolo parce que toutes les jurisprudences dont on a parlé, c'était exactement les mêmes que le professeur de Vera avait présenté en classe et je me suis dit, c'est incroyable, ce qu'on apprend c'est vraiment pertinent et je me suis sentie très chanceuse. Mine de rien.
Il y a de plus en plus une proximité entre les universités et les associations. C'est le but.
Donc on est chanceux également de vous avoir aujourd'hui, avant votre départ.
C'est un peu sur la base de cette proximité justement. Le but c'est de faire en sorte qu'on ne crée pas des générations comme nous de juristes qui en sortant de l'Union, on n'avait aucune idée de rien. C'était tellement théorique et pas pratique du tout que... Voilà.
C'est gentil pour notre génération.
Écoutez, comme ça on laisse un peu nos affaires en bonne main parce que c'est aussi ça, c'est qu'à un moment donné il faut... Les gens qui sont plus âgés que moi, l'idée c'était de construire pour eux-mêmes. Je crois qu'aujourd'hui nous on construit pour l'avenir en fait.
Je crois qu'il y en a encore comme ça. Ils voient la concurrence entre les jeunes générations.
C'est une évidence. Ça change quand même gentiment.
Merci de votre...
Avec grand plaisir. Avec grand plaisir. Every country has their own law, which means that in different countries the legal periods for use is different. I said 5 years because in most countries it is 5 years. 3 years is an exception in maybe less than 10 countries in the world.
So it can reflect the different purpose of protecting the
main reason why China probably went to 3 years is because the question of your colleague was quite relevant to drawing. Most of the drawing happens in China.
I understand.
And the reason why they reduced from 5 to 3 years is that they wanted usually it is Western owners to be able to take off the registry the trademarks and apply for the registered by traits that are not used. So it's 3 years continue, I will try to show you an example of trolling. Let me just find the right email. Okay. A client of ours comes to us only this year. This brand was created quite some time ago, in 2012, I think. The company was created. They made some clothing and sports clothing and sports material like snowboards and stuff like that for adults first, and then they focused on children apparels and bags and things like that. And their logo is this one, so with the owl and the name Namuk. And they tried to register it only after 2019, 2020 worldwide. And when they reached China, their trademark was refused based on prior existing registrations for the exact same logo. So they didn't have the budget to defend it. And they let it go, thinking, oh, we'll see later on when we have more sales, more financial power, we're more mature, etc. So at the time, in 21, their refused application was, it was refused based on 3 prior marks. Today, 4 years later, these are all the trademark registrations that we could find in China. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So talking about trolling, if you let a situation aside and you don't take care of it, it's not getting any better. So now the client will have to take time and money to get rid of all these marks if he wants to keep his trade, the possibility of registering and doing business with China. And this is not only about selling in China, but also sourcing in China. So having suppliers and manufacturers in China. So unfortunately, trolling does exist. It's a very good example of a bad case. And we're going to have to, spend quite some time on this. I think that as a next step, I would like you to try, I don't know if you've already started to think about a few brand names. I would like you to try with something that of your invention, of your idea, that you want to test in TMU as a trademark, as a word mark, Try to find out which products you want to, let's try to focus on one product, okay, one class or a couple classes, not more, and see what's coming out, and eventually assess the risk, see if it's risky or not. And I will come through and answer your questions, and we can discuss if we find it risky or not risky. And then we'll take another 20 minutes to do the same with logo searches, because I want you to see how you can also look for logos. Just a couple of remarks. When you create a brand, especially your generation, you will be quite inclined and quite naturally going towards AI. I have nothing against AI when it's used as a tool in a smart way. in brand creation, I think it can help in trying to find portions of a word, some meanings, some concepts, some derivatives, etc., etc. Find some ideas. But please never take a brand that was created by AI, whether a logo or a name. You have no security that this was not given to another user before. You have no security where your data and the fact that it is created for you will be used again in the future. And even if AI tells you it is registrable, because we do have clients coming up to us saying, oh, we created this trademark with AI and ChatGPT told us that it was registrable. Yes, but no, it's not. And you will probably have issues. So please use AI wisely and don't just use it a one by one for what they tell, what the tool tells you, okay? So do you all have one or two names you can put into the search engine? Nope. You all have ChatGPT somewhere? Or something similar? You can use Gemini or whatever. Ask him a question. Ask the tool, what is a good brand for, I don't know, a shampoo? What is a good brand name for a watch? What is a good brand name for, choose a product, see what the tool comes up with, and test it into the TM view tool with the adequate class. If you cannot find the class quickly, ask me because I can tell you the class number a bit more easily. Don't make it something complex, just go for something quite easy. Eventually, since the prompts have to be as precise as possible, ask the tool to be a registrable trademark.
You can work in group if you want.
You can work in groups. You can ask me questions. You can talk. I mean, there's a. It's not, and it's not a. It's not a. It's not a test. Huh? It's just to.
So you can
J'aurais bien aimé utiliser un par exemple. You're finding some things? Ensuite, vous allez sur l'autre, sur le petit TM View, qui est au milieu de vos onglets, encore un peu à gauche. Voilà, exactement. Là, vous retournez sur le TM View tout en haut à gauche. Voilà, là. En fait, moi, je fais ça tellement souvent que je ne sais même plus comment il faut guider les gens. Par exemple, voilà, et puis ici, voilà. Exactement, ça, par exemple, on a cherché, alors on peut faire, par exemple, un Atelier. C'est un petit peu en termes particulier, vous allez appeler comment on fait avec Flow avant. On aurait pu avoir Star Flow, ça aurait été un Flow, et on aurait pu avoir Flow Star et commencer avec Flow. Donc en fait, il y a plusieurs manières d'aller chercher. On commence par sur un en ce moment, le tien, c'est déjà pas mal. Ensuite, il faudrait normalement faire un certain nombre de recherches développées. On va en parler ici, c'est pour ça que je vais lancer un peu sur l'exercice. Par exemple, là, il faudrait faire un rêve, une toile. Voilà, et des étoiles comme ça. Ça nous donne en fait toutes les déclinaisons de ces espaces. Voilà, comme ça vous donne en fait toutes les déclinaisons. C'est pas mal. Ouais, ça rentre dans les véhicules. Ah ouais, peut-être que c'est un budget qui est pas français qui trouve que c'est super joli. On a eu Donc vous pouvez éventuellement commencer à créer quelque chose complètement différent qui va se dire peut-être que vous pouvez aussi jouer sur le côté de nouveau, utiliser l'intelligence artificielle pour générer quelque chose d'intelligent, du mot, pourquoi pas, mais peut-être que ça peut se faire en français. Ouais, ou même du coup avec enfin, mettez de la différence. Faites en sorte que vous ayez ensuite un caractère vraiment propre. So basically, you just, when you create something, ideally, go in sequence because you're just going to need it sooner or later somehow. Something will back to so ideally, you go to something where you have 1 to 5, 2 to 5. That's the problem. As I mentioned, it's a lot of ratios, and it will never be a yes or no situation. So you move from a completely no terrible to maybe it's better, but it's still not ideal. How much risk is there? Are you getting there? Yeah, we want to find the where they attack you from. And eventually we got to the project to test your markets. So eventually they started in Germany their own markets, see how the product works, making enough money, and see the reaction of consumers, etc. and then you end up saying, let's expand to the rest of Europe, and then you go because you go into the neighboring countries outside of Germany. In Germany, you will have the 2 layers. You'll have both protections, but in Austria, you will have only the European one. And in the Netherlands, you will have only the European one. In France, you will have only the European one. It's just because they started probably in Germany because they are German. So they will start in their market and then they expand. And instead of going into each country because that is very expensive, they cover the US. So you It might be word marks. Let me maybe address this with the entire record because these were questions I already heard also. So let's come back together. I suggest that we address a few questions that I heard and that we share them with everyone. One of the questions was the difference between word marks and stylized marks. If you add a logo or a stylization to your mark, how much does that differentiate and so on? Why should you protect rather the word mark or the stylized version, etc.? In general, in most countries in the world, word mark are somehow the skeleton, the core of the brand. It's a sequence of letters. Whether in most countries, if you have capitals or lowercase, it's the same as long as it's a word mark. It can then be used in any type of shape, form, size, font, stylized version, colors, etc., etc. With a word mark, you can oppose a logo mark containing the word in it. Okay, so basically your word mark will be your most important brand element. When we saw at the beginning the 4 pillars with the 4 W questions. First thing you want to do is protect your word mark. So when you have budget for only one registration, and that's your question, why did these guys you found, did they not register the word mark and the stylized version in all the countries? Well, because probably it's a matter of budget. And if you have to make a choice between both, then you go for the word mark. Also, meaning that if you find trademarks that are similar to your project, but they are very stylized, a bit like you found your prior marks that were the same, but they're very stylized, you could potentially have a very different stylization or with a different logo. And if you protect this, the distinctive parts could coexist, and you could also reduce the risk of similarity with that. So this is all about those 4 pillars. It's all about what are your branding elements. One thing is the word. Second thing is the logo. The way, what you put next to the name, what you put in the name, or etc., etc. Okay? I wanted to do some logo searches with you just to show you that it works as well. And then I want to take one of your examples so that we compare it with what I can do in professional databases. But I also wanted to show you the way I phrase and I make a search report for my customers so that you kind of see how the end product looked that I sell to customers. So I use Excel because I find it more useful, because most of those databases I showed you, you can extract data and then you can play with the line, the color, the columns, and etc. And so I have a front page, a summary that says basically where I conducted the search for what for and what date. Then I tell them if the trademark is available and or registrable or not. And then I give them a summary on what I found in terms of relative grounds being other trademarks registered, and what I consider the mark to be registrable in terms of absolute grounds meaning, is it, like we said earlier, with flow, descriptive or distinctive, or with star being laudative, and etc. Okay? And the conclusion, is it available or not for registration and use? And then I go into a table of results where I explain the risk rating, and I give medium, low, risk ratings, very low, etc. And I list basically the trademarks that I found. Okay, so just so you know, this is the way we work in terms of extracting the information that you have on those databases into something tangible that you can sell to whoever you need to sell it to. Your internal, external clients, your teachers, your professors, etc. Okay? That's one thing. And then I wanted to try maybe are you allowed to share your project names? I mean, can I use one of your names here to try something? Okay. So here, this is a professional database. So this company, Fovea, is specialized in gathering data and having a search engine. I use it because it is slightly more accurate than TMView. We'll see, comparing results with TMView, that there's not much of a difference. This is the reason why I presented TMView to you today, because it's one of the good tools. The Swiss database tool, the Swiss Reg tool, is not too bad for Switzerland, but it's a bit, I find it difficult to navigate. I find it difficult to sort the results. It used to be much easier, and maybe I'm an old schnock, and it was better before, and I don't like the new version. But TMView is much better for me, and also there's a searching tool with WIPO that is not too bad, but I have difficulties navigating it as well. So TMView, in my opinion, is one of the good ones. If we go back here to the registers, you do the same methodology. Basically, you choose your countries. So let's do EU 27, and let's add Switzerland and maybe the UK. I have my countries here. The trademark name will be, and I will try your iced tea thing, huh? So that will be here. So their name was Yumo, and iced tea is in class 32. Beverages are in class 32. This tool presents the advantage to give me results for classes that case law considers as being similar. So it will go to the foodstuff classes 29, 30, 31 automatically, and give me results in those classes as well. So that's why I'm paying a lot of money to access their data. Here it gives me nothing because I searched without any